My name's Katherine, and I'm going to be doing my current trends case brief today on the case Attorney General versus Bedford. In this case, Bedford and those she was working with asked the court to strike down 3 of the current restrictions in the Criminal Code of Canada on the sex trade. Section 210, which refers to keeping common bawdy houses, as defined in Section 197, which states a common bawdy house means a place that is kept or occupied or resorted to by one or more persons for the purpose of prostitution or the practice of acts of indecency. It also refers to Section 212, 1J, living on the avails of a prostitute, and Section 213, 1C, communicating for the purpose of prostitution. The primary argument Bedford used was that these laws, especially in Section 210 and Section 213, infringed on Section 7 of the Canadian Charter of Rights and Freedoms concerning security of the person. Bedford and her associates argued that the restrictions placed on prostitutes put them at risk by preventing them from implementing measures to ensure their safety. She is pictured below outside the Supreme Court of Canada. To back their claims, they used many pieces of evidence. First, they cited bawdy houses as a safer possible alternative to working the streets. On the streets, they faced greater risks of being preyed upon by predators, who have, famously in the past, murdered prostitutes due to their vulnerability. In their own house, they would have control over who comes and could put in place measures to ensure their safety. Secondly, they argued that people living on the avails of a prostitute could include a security guard or secretary that could ensure safety in transactions. Many were concerned about their husbands or boyfriends being put at risk if they depended on the salary of a sex worker. They said that the clause should be modified only to include in circumstances of exploitation. Finally, they argued against the third restriction, saying that allowing communication could enable prostitutes to screen potential clients and ensure they are in a safer position. This case moves through many different aspects of the legal system as an appeal case. It started in 2007 when the complaint was filed. Then, Justice Himmel of the Ontario Superior Court struck down the provisions in Section 210, 212, and 213, which Bedford and her associates proclaimed violated their charter rights. This decision was appealed by the federal government, along with other associations. The Court of Appeal upheld the ruling that the provisions concerning living on the avails of a prostitute and the bawdy house, but reversed Justice Himmel's ruling on the communication law. The federal government filed for leave to the Supreme Court of Canada, stating that the Court of Appeal had erred in its acceptance of bawdy houses and living on the avails of a prostitute. Bedford and Al filed a cross-appeal requesting a review of the communication law by the Supreme Court and to revisit the section of living on the avails of a prostitute to limit the law to have effect in circumstances of exploitation. The two main issues associated with this problem are whether the infringements in Section 7 of the Charter are justified under Section 1 of the Charter, which sets the ability of the Crown to impose reasonable limits on an individual's charter rights. The second question is, in which ways does this case differ from its precedent, which dealt with the liberty aspect of Section 7 almost 20 years beforehand? In the end, the Supreme Court ruled that the appeals by the federal government would be dismissed and that the cross-appeal by Bedford would be allowed. What this means is that all 3 of the provisions would be struck down with the exception of the final one, which had been open for some room to debate, living on the avails of a prostitute. This would now be only applicable in cases of exploitation, as Bedford had wanted. Section 1 of the Charter allows reasonable limits to rights and freedoms. However, in order to restrict an individual's rights, the case must be considered acceptable, using the Oakes test to ensure the purpose of the law is demonstrably justifiable in a free and democratic society. The three provisions in question, Section 210, Section 212, and Section 213 of the Criminal Code, attempt to accomplish a pressing and substantive objective, according to the morals of free and democratic society. The provisions aim to prevent public nuisance and to protect prostitutes from exploitation, which could certainly be argued as such an objective. However, the ample evidence presented concludes that these provisions force prostitutes into more dangerous situations. The provisions also cause prostitution to be brought to the streets, where it causes a greater public nuisance. Section 1 of the Charter therefore cannot justify these provisions, because, while they try to limit rights to achieve a pressing and substantial objective, the laws do not have a rational connection to fulfilling their objective, and they impair the ability of prostitutes to preserve their safety. This conflicts with the rights outlined in Section 7, including the right to communicate, and, primarily, the right to safety of persons. From this, the conclusion can be drawn that the provisions in Section 210, Section 212, and Section 213 are not in accordance with several fundamental principles of justice. This case answers an entirely different question than the previous case regarding prostitution, which concerns itself more with liberty. It is also different due to its violation of the principles of arbitrariness, overbreadth, and gross disproportionality, which have developed since the last time a similar case was in trial 20 years ago. This shows the court is justified in differing from its previous decision and striking down the provisions in light of the substantial and distinct evidence in support of their decision. This case is a milestone case for the rights of sex workers and also for the rights of other minority groups living on the edge of social norms. It may allow prostitution to be more accepted in society and for the rights of sex workers to be recognized. I think that the ruling makes a lot of sense, considering prostitution had previously been made legal. However, there were still these regulations, which were very arbitrary and seek to impose restrictions due to the inability of the courts to make a firm ruling on the matter of prostitution. This unfairly marginalizes sex workers and interferes with their rights to safety of persons while achieving no reasonable objective. I therefore think that the Supreme Court acted logically in striking down these laws. Do you think that compliance with the laws before this case, which prohibit communication for the purpose of prostitution, operating out of a body house, and living off the avails of a prostitute, infringe on sex workers' security of persons?